question during the first panel. I think there were a very interesting comment about the specificity, the uniqueness or not of the central banks. We will now travel a little bit around the world with three speakers. Sharon Morris, Eugenio Gracia, Udo Bro, and Frédéric Allemand. We had a fourth panelist scheduled, Professor Fromage, but she is unfortunately sick, and we wish her a prompt recovery. So I think we will start with Eugenio Gracia Udo Bro, who is an assistant professor at the Catholic University of Chile, Law School, and a fellow at Yale University Council on Latin American and Iberian Studies. He is also a regular columnist for El País and a GSD candidate at Yale Law School. Eugenio, the floor is yours.
Thank you very much. Let me share 1 second. Can you see the presentation?
Yes, perfect. It was good.
Oh, that's fantastic. That's fantastic. So thank you very much. And thank you very much for the organizers. I'm delighted to take part of the webinar and to contribute from a perspective from Latin America. Because Latin America encompasses a wide range of experiences, I'll have to be very synthetic. So I'll proceed in 3 quick steps. First, I'll briefly highlight what, if anything, makes central bank independence distinctive as an institutional arrangement for those less familiar with central banking. Second, I'll offer a highly synthesized overview of how central banking independence has been designed and contested across Latin America. And third, like to connect with the broader discussion, I'll reflect on what about this regional experience might help illuminate the US current predicament, particularly the issues raised by Trump v. Cook. Obviously, it goes without saying that my aim is not to offer any prescription, but to provide a few comparative lenses that might help frame the broader discussion. Because one should not miss that the American case is framed within a broader constitutional trend in the country, which is the aggressive expansion of the executive under the banner of the unitary executive theory. So I guess it might be illuminating to examine the trajectory of hyper-presidential regimes in Latin America and the decades-long effort to create credible, independent central banks, as well as the threat that they continue to face. So without further ado, first, what is distinctive, if anything, about central bank independence? We might point to some ideas both from economic and legal literature. The first, which is more an analytical lens rather than like an empirical clean-cut observation that works as a one-suit-fit-all, is the mandated structure of central banks, especially when it comes to monetary policy. And this is the first element that one might consider that makes it different from regulatory independent agencies or fourth branch or guarantor institutions. Central banks' independence, especially in monetary policy, rest on the separation between means and ends. Elected politicians retain authority over the ultimate objectives of monetary policy: price stability, employment, financial stability, while central banks, to a certain extent, are granted broad discretion over the instruments necessary to pursue those goals. So independence might, on a first level, operate like at the level of means and not ends. And that is best understood as accountability enhancing rather than accountability evading, with a company with certain practices as ex-ante rating fixation, like public reports, congressional hearings, etc. But even if we...
Eugenio, sorry, but we see your text, but not your PowerPoint. Can you maybe switch to your PowerPoint, please?
Oh, sorry about that.
Thank you.
Okay, fantastic. Thank you. But even so, like if we accept that this is not accountability problematic, like this posts central bankers as discretionary macro policymakers. This institutional arrangement, of course, reflects a classic credibility problem, as monetary policy is uniquely vulnerable to the famous problem of timing consistency. So delegating instruments to instrument control to an independent authority serve as a credible commitment device. stabilizing expectations and anchoring economic behavior. So in that sense, sorry. I don't know why it doesn't seem to be working. Oh, in that sense, independent is not primarily or uniquely about expertise or technocracy that needs to be guarded, but also about expectation management. Because and this is related to the second distinctiveness, the functional role of credibility. Because unlike many regulatory agencies, central banks operate in an environment where expectations about the future policy are themselves policy relevant. Monetary decisions are transmitted through financial markets, contract, wage setting behavior. So independence performs a signaling function that is central to policymaking effectiveness that it's not so clearly in other regulatory agencies. Sir, one we might, at least in Latin America, it's quite clear. Central banks typically enjoy a degree of institutional and financial autonomy that exists that most of independent agencies. They have budget autonomy, control over internal governance, and especially they are insulated even in only as de facto from the annual appropriation processes that reduce opportunities for indirect political leverage and reinforce credibility over time. I mean, they don't have to subject to congressional appropriation. In pretty much all Latin American countries, they, with the exception of Venezuela to a lesser extent, Ecuador, they have like broad discretion over their balance sheets, which is a structural safeguard. And what's not normally highlighted in this discussion is that also central banks are uniquely transnationally embedded institutions. And in so, their authority is not shaped only by domestic constitutional and statutory arrangements and politics, but also by global financial markets, international standard setters, and transnational policy networks. Credibility in this transnational environment is monetary, rewarded, or punished by bond makers, rating agencies, and international financial institutions. This obviously is, in terms of like asymmetry, is evident in Latin America as, for example, in the 1920s, most of modern configurations of central banks in South America were shaped by US influence through the famous Khmer Commission. But it's also more recently evident, like central banking independence in Mexico arose pretty much from American impositions during the NAFTA negotiations and was constitutionally entrenched largely because of that. Or, for example, in Ecuador, only a couple of years ago, like the central bank was reestablished as an independent institution based on IMF conditionalities. But I mean, this is even clear for different reasons for like more developed and rich countries. For example, last week's statement by Global Central Bank chief in support of Chairman Powell after the Trump administration threatened him with the criminal indictments point to this reality. And importantly, such strong endorsement that not comes from pure collegiality, from actual embedded interest, as the Fed provides crucial support to other central banks through coordinated swap lines, which makes them like transnationally related. Finally, before moving to Latin America, does independence make any difference? And before the Great Depression, like the 2008 crisis, empirical studies seem to suggest that there was a strong empirical correlation between independence and inflation outcome. But since then, after crisis, new studies seems to suggest that there's a lot of endogeneity in formal practices and an important gap between the jure and de facto independence. The more defensible conclusion, based on these new empirical studies, especially for Latin America, is that independence, as Michael or David was saying, is a matter. Independence matter as part of a institutional ecosystem, interacting with fiscal policy, political norms or practices, and market credibility, which is especially important for constitutional architecture's structure as hyper-presidential regime. So, taken together, these features help us explain why central banking might occupy a sui generis position among fourth branch or guarantor institutions. They combine macroeconomic reach, deep financial embeddedness, and unusually strong formal autonomy with consequences that extend beyond any single policy domain. So, Latin America. Turning to Latin America, I want to begin by stressing the remarkable convergence in the formal architecture of central banks independent across the region. Because countries across Chile, Mexico, Colombia, Peru, and Argentina, independence is almost universally recognized in law. In most cases, constitutionally entrenched, with some exceptions in statutes such as Argentina or Costa Rica. Board members and chairmen typically serve fixed staggered terms. Removal is formally limited to defined causes. Monetary financing of the state is broadly prohibited, and inflation targeting frameworks are combined with robust transparency mechanisms are widespread through the region, with the exception of Venezuela and perhaps to a lesser extent Bolivia. So when we see, I mean, obviously I cannot cover to all the specific details, but like you have on paper, that most Latin American central banks closely resemble textbook model of modern financial monetary authorities. Their formal architecture, at least in legal text, is more explicitly entrenched than in many other OECD countries, which is partly a result of the trauma of hyperinflation during the 80s. But as law only tells you apart in Latin America, at the same time, this convergence coexists with other shared structural vulnerability, which might be interested to consider for the American context. Executive center appointment processes. While some systems include legislative confirmation, with perhaps the only noteworthy case to mention Colombia, which is only presidentially appointed, and Peru, which is a split appointment mechanism, certain board members by the president, others by Congress, though the presidential nominees have to be approved by Congress. And in pretty much all cases, there's a legislative confirmation. Supermajority thresholds with low party discipline and strong veto points are rare. Reappointment is often permitted, even with long terms, as just Chile, which is a 10-year term, creating incentives for political alignment over time. So, as a key element of this point is independence in Latin America, at least, is frequently shaped upstream at the moment of the appointment, rather than downstream through overt removal, which is especially important in Mexico, as this Mexico has been a textbook of how to seriously create in central bank independence. Though during the AMLO administration between 2018 and 2014, like a way in which they control the central, or to a certain extent control the central bank, was through the appointment process rather than redesigning the bank as it happened to all other guarantors institutions. So, a second fault line, which the Latin American experience highlights, is fiscal dominance. Pretty much all countries have formal prohibitions on monetary finance, but the resilience varies across fiscal stress. Comparing cases such as Chile, Peru, to a certain extent Colombia, with Argentina illustrate how very similar legal rules can produce very different divergent outcomes, depending on fiscal discipline and credibility. In practice, then, what Latin America teaches is that fiscal dominance, even more so than legal architecture, is the principal test of independence. Consider Colombia, for example. Colombia is provided of more formal guarantees to protect central bank independence, yet it exhibit like a much more de facto independent central bank than other countries, like, for example, Brazil, that has much more legal protections. So, to start concluding, These share features point to a broader insight. Central bank independence in Latin America operates as an institutional ecosystem. Legal entrenchment, appointment politics, fiscal policy, transparency, and external credibility interacts over time, producing very different trajectories. And just to capture that, we can point to similar architectures with very different trajectories. What I call, uh, I didn't find a very name, but stabilized independence. We can point as a representation of this ideal type Chile, and the hollow out independence, Argentina. So when framing these different trajectories, like the first, which is represented in Chile, the stabilized independence, here strong legal insulations is reinforced by fiscal discipline, predictable appointments in terms of practice, and market credibility that is constructed over time. So in that way, legal independence becomes self-reinforcement, and political interference is widely understood to be extremely costly. And I point this like in Chile, in the early 2000s, there was a crisis involved the chair of the bank, which certain parliamentarians thought it was impeachable. But they realized it was so costly in terms of reputation for markets to impeach him, that they decided to let it go. Um, and also, it's important that fiscal discipline and the fact of monetary policy remains completely separate, monetary and fiscal authorities, even when stressed, as for example in the 1997 Asian economic crisis, where the board of the central bank had a very strong clash against the Minister of Finance. As opposed to, for example, the second model, that is the hollow out independence, where legal architecture is similar to the first one and remains largely intact, but autonomy erodes through fiscal pressure, politicized appointments, declining credibility, often without any legal rupture, which might be explained, for example, in a famous case in the 2010, where President Cristina Fernandez tried to finance public debt with the treasure fund, with the bank funds, but the chair opposed, and she tried to dismiss it, even though they were for costs and procedures for removal. Um, that case of the district and then an appeal court give injunction to reinstate the chair Redrado, but the political pressure was so sustained that he finally resigned, and that led to many other resignations from board members. And that was followed not by the completely redesigning the central bank structure, but just to intervene the mandate in terms of like subordinating to fiscal policy. And that also obviously overall eroded the credibility of bank. A final thought on Latin America. The region experience highlights multiple enforcement mechanisms. Well, they can enforce or undermine independence. Markets often discipline, political encroachments through immediate credibility cost, as illustrated, for example, by the current administration from the President Lula against the bank, or by the former Mexican administration against the chairman and the board members. And in this case, pretty much like the political pressure were contained because there have been no removal in Brazil, nor were in Mexico, partly because of market backlashes. A second element is that courts can act as guardians of independence, as, for example, when political pressure arises, for example, in Colombia and Argentina. I already mentioned the case of the judicial injunction of Chair Redrado, but in Colombia, there's another interesting case in which there was sustained political pressure, and the executive tried to enforce a general retirement rule that capped all public offices to a 70-year limit. But the court said that limitation cannot apply to the bank because it would affect the staggered terms of the bank. Transnational pressures, I already discussed that, and also mandate manipulation. I already covered that. Finally, to conclude.
I think that we might leave the last part for the discussions because we are
Sure,
already a bit
sure.
if you don't mind.
Sorry.
Thank you. Thank you
Thank
very
you.
much. Let's turn to Shireen. Shireen, you are the Director of Research and Innovation and an Associate Professor at Macquarie University Law School in Sydney, Australia, and you specialize in constitutional law, and you wrote on central bank independence in Australia in a recent article published in the UC Berkeley Journal of Law and Political Economy. I think you have a PowerPoint that you are presenting to us. Please, the floor is yours.
Thank you so much. Can you see the PowerPoint okay?
Yes. Fine.
Wonderful. So as you said in your introduction, and thank you for the opportunity to be involved today, I'm very much coming at this from a constitutional law, public law perspective. So what I want to do in my short presentation is give you a bit of a snapshot of the way central bank independence manifests in Australia. So just some constitutional context to start with. Australia is a parliamentary democracy. It draws from British constitutionalism, but also US constitutionalism in that we are a federation. So there's an executive at the Commonwealth level and also at the state and territory levels. We have a written and entrenched constitution. The Reserve Bank of Australia, the RBA, is not entrenched in the Constitution. It's a creation of statute, most likely enacted under the various banking and currency, etc., heads of power in the Constitution. So the Reserve Bank Act of 1959 establishes the RBA as a Commonwealth executive agency. Now, what I think is interesting about the Australian situation, which perhaps resonates a little bit with what I heard about the UK situation, is that the RBA Act establishes what I would describe as a nuanced and qualified independence, not complete separation from the elected government. And one more framing thing that, like the UK, we don't have a strict separation of powers in Australia, right? We've got responsible government. So members of the executive also sit in Parliament. So just a little bit quickly about the origins of the Reserve Bank. It occupies this nuanced position at the intersection of government influence and private financial influence. And I think that is a lot to do with its historical origins, because the Reserve Bank was preceded by the Commonwealth Bank, which undertook ordinary commercial activities. And it shared powers of note issue with the government. And what you saw was an enlargement of the Commonwealth Bank's powers under wartime rules. Now, the Commonwealth Bank slowly evolved these central banking functions and became more of an outspoken player in economic debates. And those central banking functions that evolved were formalised through legislation in 1945. So this hybrid public-private model evolved, yeah? And one thing I would note there is that the current RBA charter requires it to pursue goals of price stability and full employment under the overarching goal of in relation to pursuing the prosperity and the welfare of all Australians now and into the future. And that is a continuation of its mandate under the 1945 Act. So what the RBA Act did, which came into force in 1960, was detach the Commonwealth Bank from the new RBA, separating out those public and private functions. And the Commonwealth Bank still operates in Australia as a commercial bank. So that original corporate body was maintained, but the title was changed to Reserve Bank of Australia. But what I think is really interesting from my perspective is that this bill, this legislation in 1959 was enacted amidst a struggle for control over monetary policy that you could see playing out between elected representatives, particularly on the Labor side, and the private financial sector. So in the Australian Labor Party, there had been long-standing suspicions of financial power. So the Labor Party wanted to retain public control over monetary policy. And they worried that the Menzies, the Liberal government's RBA bill, would shackle the power of Parliament over monetary policy. By contrast, Conservatives saw the bill as the antidote to the Labor Party's failed attempt to nationalise or socialise the banking system. And that attempt, that legislation was constitutionally invalidated in the 1948 bank nationalisation case, right? So the Menzies Liberal government, this all comes out in the parliamentary debate, wanted to induce cooperation between the central banks and the private bank, and wanted to ward off Labor's attempted socialisation of banking, which had nonetheless failed constitutionally. So what's interesting there is that an explicit policy aim was not only to foster independence from government, but to encourage cooperation with the private financial sector. Now, in contrast to that somewhat black and white ideological debate that played out in the Parliament, the Act itself is more nuanced. You look at the provisions and it establishes tempered independence under ultimate elected government control. There are various provisions in the Act that establish expectations of dialogue, partnership, information sharing between the executive elected government and the Reserve Bank, so not strict separation. And one example of this is that the Banking Act, which came into force simultaneously with the RBA Act, empowers the central bank to set interest rates with the approval of the Treasurer. And importantly, Section 11 of the RBA Act establishes the Treasurer's veto. It's quite a detailed procedural provision that encourages agreement between the Treasurer and the Governor of the Reserve Bank, but gives the Treasurer an override power as a last resort. And it's a multi-layered procedure. It sort of says if agreement's impossible, then the RBA has to give the Treasurer a statement explaining its position on the matter. The Treasurer can submit a recommendation to the Governor-General, who, acting with the advice of the Federal Executive Council, can determine the policy that the central bank must adopt. The Treasurer must inform the RBA of the imposed policy and confirm that the government accepts responsibility for the RBA's adoption of that imposed policy. If those steps are fulfilled, then the RBA has to implement the imposed policy. And finally, the Treasurer has to table in each House of Parliament a copy of all of those relevant documents. Notably, these lines of democratic accountability that the Act establishes cohere with well-known principles of responsible government in Australia, right, drawing from British traditions, namely the idea that departments or agencies of the executive are responsible and accountable to their minister, in this case the Treasurer, who also sits in Parliament and therefore is ultimately accountable to the people. So the Liberal Senator William Spooner, reflecting on the bill's inclusion of this Section 11 veto power, commented on this during the parliamentary debate, and he said, while a great measure of independence is to be given to this Reserve Bank, and while no government would likely interfere with what it will do, in the final analysis, the government must reserve to itself the right to disagree with what the bank does. The government should do that only in circumstances in which disagreement is brought out before the Parliament so that all may see the effect of it, right? So this idea that in exceptional circumstances, the elected government should have the right to overrule the bank, but it must only do so with supreme sort of sunlight and democratic scrutiny. Now, notably, as I heard is the case in England, the veto has never been used. So there is this strong convention that it is this nuclear button of monetary policy to be used only in extreme, exceptional circumstances. And in that sense, it reminds me of the Governor-General's reserve constitutional powers, which also by convention are not used except in exceptional circumstances and operate as a kind of constitutional fail-safe. But I think it's interesting to note that threats of the veto, threats of using the veto have been effective. And the former Prime Minister and Treasurer, Paul Keating, talked about how he threatened to use the veto to force the Reserve Bank to raise interest rates to fight inflation, which I think is interesting because it's contrary to the usual concern that the political actors will force the Reserve Bank to lower interest rates, right? In this case, he was encouraging or speeding the bank up and saying, hurry up and raise interest rates. John Howard, Conservative former Prime Minister and Treasurer, also threatened to use the veto to force to get the RBA to compel the private banks to lend in a particular way so as to encourage home ownership. I think it's also important to note that the original Act did not mention independence. Yeah. So in practice, after the 1959 Act came into force, monetary policy was still set by the Treasury in line with the more interventionist pursuit of full employment by post-war governments. This changed not through legislative amendment, but through policy and practice, so that by the end of the 1970s, at least, we saw the abandonment of full employment as a national policy, the elevation of inflation control as the headline objective, and at the same time, the financial landscape being deregulated. So in the 1980s, the Labor government oversaw the Accord, which agreed to wage restraint in exchange for a social wage and adopted an inflation target of 2 to 3%. That was under the ALP. In the 1996 agreement between the Howard Conservative government and the central bank embedded that inflation target, which has stayed the same since. Now, notably, I would argue that the RBA's contemporary deprioritisation of full employment in favour of inflation targeting could arguably appear in contradiction to the legislated mandate, although it has occurred under successive executive agreement. So I point all this out to show that in Australia, central bank independence grew through policy and practice in an entwined way with the rise of inflation targeting and the deprioritisation of full employment. Now, currently, let's go back to what happened in the last few years. There were amendments to the Act in 2024 which inserted reference to independence in the Act. There had been an RBA review in 2023 which advocated not only for increased independence, including elimination of the Section 11 veto, but also for increased coordination between monetary policy and fiscal policy. That raises a question in my mind, right? How do you have increased independence or separation at the same time as increased communication and coordination? That there is a tension there, I think, which deserves further discussion. Following the RBA review, in 2024, the Labor Party in government attempted to relinquish the government's override power. So I think that's interesting because you think about where the Labor Party travelled from, from the inception of the Act, trying to cling to democratic control over monetary policy, to 2024 being the party trying to relinquish that democratic control. Ironically, the Conservatives, the Liberals and the Greens, and many experts opposed that move. And many argued that the veto should be retained because it properly gives primacy to democratic power. And Paul Keating, the Labor Prime Minister and Treasurer who led the liberalisation of Australia's economy, he said interest rates should never be set by a bureaucracy, however expert, remote from the vicissitudes of society and the real economy, right? So he's highlighting there the importance of central bank being alive to democratic concerns, notwithstanding independence. And even former RBA governors like Ian Macfarlane sort of said the RBA's power is not God-given, rethink giving up the veto. And former RBA Governor Bernie Fraser advised against an unchecked committee of economic super nerds running monetary policy absent political scrutiny. I want to say something quickly about appointments. So following that 2023 RBA review, the 2024 reform split the RBA board. Now you've got one board that focuses on operational matters, the other on setting interest rates, in addition to the payment systems board. The new Monetary Policy Board comprises the Governor, Deputy Governor, Treasury Secretary, and 6 external members, which is basically continuation of the previous setup. The appointments all tend to be monetary experts, business leaders, etc. In the past, at times, Australian union advocates have argued that worker representatives should again be granted RBA board positions to facilitate diversity of input, particularly given the impact on employment outcomes that Reserve Bank decisions can have. Notably, this occurred in the past, in the 90s, when trade unionist boss Bill Kelty sat on the RBA board. In terms of independence, the 2024 reforms inserted a new stipulation that the Treasury Secretary acts on the board in their individual capacity, not at the direction of the Treasurer. The amendments further specified, subject to the rest of the Act and other laws, that members of the Monetary Policy Board must have complete discretion, must act in an independent and impartial manner, there's the mention of independent, and must not be subject to direction from anyone, including the government. But I draw your attention to the fact that those strong words are nonetheless subject to the rest of the Act and other laws, which means they are subject to pre-existing provisions like the veto, like provisions requiring communication, information sharing, etc., and the provision in the Banking Act that requires interest rates to be set with the approval of the Treasurer. Yeah? So it's unclear how these new independence enhancing provisions work in practice as against those other provisions. In terms of appointments, the Act stipulates that Monetary Policy Board members are appointed by the Treasurer. The Governor and the Deputy Governor serve 7-year terms, and they hold office subject to good behaviour. Now, I haven't been able to find details or case law illuminating how some of these provisions work in practice, perhaps because none exists, right? I haven't been able to find instances where these provisions have been used. The Treasurer may terminate external board members for misbehaviour if they're unable to perform duties, etc. The Treasurer must terminate external board members if they become bankrupt, excessive absences, etc. And pictured there is the current Governor and the former Governor behind her. Last thing I want to say, because it relates to this question of justiciability, yeah? Should decisions of the Reserve Bank be justiciable? Now, in contrast to the savings clause that I had a quick look at in the Feds Act, Section 87 of the Reserve Bank Act provides that the validity of an act or transaction of the bank shall not be called in question in any legal proceedings on the ground that any provision of this act has not been complied with. So it's a legislative attempt there to shield RBA decision-making from judicial review. Now, in the seminal case of Plaintiff S157 in 2003, that case established increased constitutional limits on legislative attempts or ability to oust judicial review through privative clauses, and confirmed the primacy of the Constitution's guarantee of judicial review. What is interesting is that a few months after Plaintiff S157, later in 2003, there was this case of Visa Services International versus the RBA, which was a case about the RBA's payment systems decision. The RBA notably did not argue that Section 87 blocked judicial review. It instead argued that it should influence statutory interpretation to ensure wide discretion and no particular enforceable duties on the part of the RBA. So taking that argument into account, but not accepting it completely, the Federal Court treated Section 87 not as a bar to judicial review of RBA decision-making, but as a possible indicator that judicial deference should apply in interpretation of the relevant provisions. So I'll leave my presentation there and look forward to discussing with you more as the conversation progresses. Thank you.
Thank you, Shireen. And that's very interesting to see that although there are lots of difference compared to the previous panel, difference come back again in some form. Thank you. So we will move to the French system with Dr. Frédéric Almond, who is a researcher in public law and coordinator of the Robert Schuman Initiative at the University of Luxembourg. I will give the floor to you for the sake of time.
Yeah, thank you very much, Iseult, for giving me the floor. And if I'm right, the webinar will start automatically in 20 minutes, so I have to rush a little. So, as Iseult said, my name is Almond. It means German. I work in Luxembourg, and I will analyze the Banque de France. So you see, this is perfectly Europe. Alors, before detailing the bank's independent status, I would like to share with you historical background to show how special, how unique is this institution. As you maybe know, the Banque de France was founded in the 18th century, making it one of the oldest central banks in the world. When the bank's statutes were first revised in 1806, Napoleon Bonaparte is reported to have said, "I want the Banque of France to be sufficiently under the control of the government, but not too much." Since then, the nature of the relationship between the Banque de France and the government has been a constant source of debate. Without going into detail, the history of the bank's independence from the government can be divided into three main periods. From 1800 to 1936, the bank was established as a public bank with private capital. The 200 largest French shareholders ran the bank and ensured that the implementation of the public missions remained perfectly in line with their own private interest. From 1936 to 1972, the bank was tasked with supporting the needs and interests of the government. Clearly, the bank's governance was revised in 1936 to reduce the control exercised by private bankers in favor of government representatives. In 1946, this is the end of this process, the bank was nationalized. And then from 1973 onwards, the bank became independent from the treasury. Monetary policy took into account the liquidity needs of the monetary markets and no more the liquidity needs of the government, and the governor's management powers were strengthened. As you know, in 1993 and 1998, the Bank of France statutes were revised to bring them into line with the Maastricht Treaty, so that France could adopt the single currency in January 1999. Since then, further legislative revisions have been adopted. These have simplified the bank's governance, enhanced the governance management powers, and modified the appointment procedure for the governor and the two deputy governors. And to say it, in its 225-year history, only two governors have been removed from office to date. The first in 1881 and the second in 1926. But at that time, no legal guarantee of independence applied. To put it another way, until 1993, governors were appointed and removed from office ad nutum, meaning only a simple letter by the Prime Minister was sufficient to appoint them or to remove them from office. However, it never applies except in the two cases I've mentioned. A few governors have not completed their term of office to date. However, in each case, their departures were linked to resignations to take up new responsibilities in the private sector, in the public sector. For example, this was the case of Sylvie Goulard, second deputy governor in 2022 who left the bank for the Ministry of the Defense, or they could also move for international financial organizations. That was the case of Michel Candesu in 1987. To fully understand the situation in France, I will now discuss very shortly the legal framework of the Banque de France, and if I have enough time, I will also focus, maybe that matters the most, on the provision relating to the personal independence of the members of the Banque de France governing bodies. First, very shortly, the legal framework. The French Constitution contains no provisions on monetary policy or the Banque de France. This could be a little bit surprising, but the reason for this absence is clear, is very easy to understand. In accordance with Article 20 of the Constitution, the government defines and conducts the policy of the nation. And as the Constitutional Council ruled in 1993, monetary policies is, I quote it, an essential and integral part of the nation's general economic policy. It means that monetary policy became functionally and institutionally separate from general economic policy only with the start of the second stage of EMU, of the Economy and Monetary Union, on the 1st of January 1994. And then when France adopted the single currency in January 1999. On these dates, the provisions of the European treaties began to apply in the French legal system in accordance with the French Constitution, I mean Article 80, paragraph 2. The statutes of the Banque de France today are only set out in the law. So it means that they may be amended by the Parliament on the initiative of the government or of MPs. Since 2000, the statutes have been codified in the Monetary and Financial Code. A decree adopted by the Prime Minister after consultation with the Council of State, the Conseil d'État, sets out the detailed rules for implementing the legislative provision. The legal compatibility of the statute of the Banque de France with the requirement of EU law was reviewed by the European Commission and the European Monetary Institute, now the European Central Bank, several times in the past, before France adopted the single currency. And at that time, only a very few minor issues were identified and corrected. Since then, the ECB has issued more or less 50 opinions on French draft legislation or regulations, falling into one of its areas of competence. 3 opinions issued by the European Central Bank concerned directly the governance of the Banque de France, and no one of them raised any specific criticisms or suggestions for amendments. So it means that France government or the Parliament perfectly comply with EU law and its constitutional requirements. They are perfectly respecting and complying with all the independence requirements laid out in European treaties. What to say about the uniqueness now of the Banque de France? From a legal perspective, the Banque de France is an institution that does not fit into the usual national legal categories, clearly. According to the case law of the Conseil d'État and also another jurisdiction called the Tribunal des Conflits, the Banque de France is, I quote them, a sui generis public entity distinct from the state, which is entrusted by law with missions of administrative public service without having the character of a public enterprise. It has a special nature and specific characteristics. So, what are these specific characteristics? Maybe the most obvious is the status of its staff, but I won't enter into the detail. I will only focus on the personal independence of the members of the Banque de France governing bodies, if I still have time. So now I must say a few words about the personal independence of those members. Since the legislative reform in 2008, the governance of the Banque de France has been clearly deeply simplified. The bank now comprises 2 managing bodies. The General Council, this body is responsible for the general administration of the bank and the management of the bank's activities, and it is important, other than those relating to the Eurosystem's task, so the European system of central bank. This General Council comprises the governor, the 2 deputy governors, and 8 other members. 2 are appointed by the French Assembly, 2 others by the Senate, and 2 members by the French government. In every case, and this matters, members have to be appointed considering their expertise and professional experience in the financial or economic fields, and no one can hold an elected office. The 2 last members are not purely external to the Banque de France. One is a representative of the staff of the Banque de France, and the other is the vice president of the Prudential Supervision and Resolution Authority, which is a body separate but closely linked to the Banque de France. All these members are appointed for a non-renewable 6-year term, and nothing is said about their independence or any legal guarantee they may enjoy. However, this General Council is responsible for ensuring the independence of the Banque de France. So we could expect, and we may expect, that all the legal guarantees that apply to the governor and the 2 deputy governors could also benefit to those members when they review the independence of the Banque de France and its different members. What about now about the governor and the 2 deputy governors? The governor is responsible for the management of the Banque de France. He adopts the measures, or she adopts the measures necessary to implement the guidelines, decisions, and so on taken by the ECB on matters relating to the real system tasks. The governor is assisted by 2 deputy governors who perform the duties delegated to them by the governor. So that's clear, that's very usual. The governor and the 2 deputy governors are appointed by decree of the Council of Ministers for a term of 6 years, renewable once. The governor is appointed by the President of the Republic after a positive opinion issued from Parliament. The candidate considered for the position of government of the candidate considered for the position of governor is interviewed by the parliamentary committees responsible for monetary matters. And the renewal of the position is subject to the same procedure. This means that the governor, whose reappointment is being considered by the President of the Republic, must be interviewed again by the parliamentary committee. And to be honest with you, the prospect of reappointment could put pressure on candidates. To our knowledge, the ECB has never issued a negative opinion on any reappointment procedure as long as the reappointment is for a minimum term of 5 years. But the ECB has said absolutely nothing about that kind of, let's say, pressure when the reappointment procedure is implemented. Alors, I've had a look at the last reappointment, and it concerned Governor Villeroy de Galhau in October 2021. And he said that this new hearing before the parliament was, I quote him, an essential democratic step and the only one that legitimizes independence. So it's a little bit surprising. It should note, however, that there is an age limit for the position of governor and deputy governors. The limit is set at 65 years, which is the standard for high civil servant position. And when they reach this age limit, the governor and the 2 deputy governors remain in office until the end of their current term. But they can't be renewed anymore. Maybe I have to conclude. If we want to have a very short discussion, if I'm right, Iseult. So yes, it will be very short. The fact is that what about the condition to be removed? And here, the statute of the Banque de France are just a copy paste of the European treaties. And they had absolutely nothing. And the ECB was very clear in its opinion in the past that it doesn't want that the statute had anything else regarding the Article 14, paragraph 2 of the ESCB statute. So it said that the governor or the deputy governor could be removed if it doesn't if it does not fulfill anymore it can't no more fulfill its task, or if there is a misconduct. However, nothing is defined. We only know that in Rimsewicz case of 2019, the Court of Justice ruled that criminal offenses, were it to be established, would constitute serious misconduct. That's all. However, we have an interesting example. In France, it deals with the situation of Jean-Claude Trichet, who was a former governor of the Banque de France. As you maybe know, one of France's major banks, Crédit Lyonnais, had come close to bankruptcy as a result of excessive financial investment and had to be recapitalized by the French state at a cost of several tens of billions of francs. A criminal investigation was launched in 1996 on suspicion of disseminating false financial information and publishing inaccurate financial statements, and the governor of Banque de France, Jean-Claude Trichet, was prosecuted for complicity as he was director of the Treasury and exercised supervision over Crédit Lyonnais at the time of the alleged offenses. And what is interesting is that French President Jacques Chirac criticized clearly Trichet at the beginning of its mandate for not lowering a key interest rate in 95-96. And he was not supporting, and the Banque de France was criticized for not supporting the French economic policy. In fact, the French president had sought to put pressure on the governor of Banque de France by publicly pointing to Trichet's responsibility in the Crédit Lyonnais scandal. To make that long story short, Trichet was cleared 3 months before being appointed president of the ECB. And this is the end of my presentation. Thank you very much.
Thank you very much, Frédéric, for trying to make the time. Just a question. Do you think that there is some kind of story or lessons or link with what is happening in the US from what you just said? Or is it complete? The institutional context is so different that there is absolutely no connection at all that could be made, because
the context is slightly different. We are more keen to respect the rule of law in France than maybe somewhere else. However, what we see with the example that I give about President Chirac is you can have a discussion, a debate between the government and the governor of the Banque de France. The question is, to what extent you will explain to the governor that maybe if you want to be renewed, he had to make some effort.
It's the pre-appointment hearing is something that you have also in the UK. I mean, but it's not constitutionally protected. It's much more informal. Fine, yeah.
That's also the case in France. It's just mentioned in the law. So it could be an organic, what we call an organic law. However, Villeroy de Galhau, so the current governor, thought it was very positive to have this kind of hearing because it gives him the possibility to explain what is the mandate of the Banque de France and how he contributes to the French economy and in a more to the European economy. So I think it's still positive, and when he exercised its mandate, it's totally independent at that time.
Okay, thank you very much. I don't know, Oren, do we have another 5 minutes, or is it time?
So when I get to time, because of my students, I always feel like they're slinging arrows at me if I go over time. So my tendency is to say thanks, and hopefully we'll have other opportunities to discuss. I guess that I think that we just don't have time. We'll have to end the webinar. But thank you so much, everyone, for the panelists in this part of the webinar, and to all the attendees. Just so you know, this is recorded, and this is going to be just circulated through the Comparative Administrative Law listserv, but also we'll be posted, am I right, result on the Review of European Administrative Law blog, Real Law blog. So thank you very much once again, and especially those who are in challenging times around the world. See you soon.